everyone. I think that I am live now. My name is Emily Sumner with Sumner Immigration Law. If you've been waiting to join the meeting, I apologize. I'm using StreamYard and hadn't connected that to a LinkedIn event before. So I apologize if you have been waiting, but I appreciate your patience. I'm so glad that everyone is here, whether you're joining us live or catching the replay. We have asked people to submit questions before. We are talking about the H-1B, the $100,000 H-1B fee that Trump announced on Friday afternoon. So we have asked people to submit questions ahead of time. If you have additional questions, put those in the comments. I am going to tell you what I'm going to talk about, then I'm going to talk about it. A lot of that will cover the questions that we've already received. But if you have questions, absolutely put those in the comments and we will answer those as we can. As always, this is not legal advice. This is for informational and educational purposes only. So what has happened? On Friday afternoon, a headline came out, late Friday afternoon, a headline came out that said that Trump would require a $100,000 fee for H-1Bs. That was what was in the headlines. Then later on Friday, he issued a proclamation, which is different from an executive order. I honestly don't know the difference, but anyway, he issued a proclamation on Friday with some additional information. I want to be clear that even now, even on Tuesday, several days after the proclamation was given, there's a lot of information that we still don't know for sure. So we'll be talking about that. So what we're going to be talking about today is what actually happened, what we know now, who it affects and does not affect as best we know right now, what we don't know right now, and what to expect next. So like I said, he issued this proclamation on Friday. So Saturday morning, we're getting, of course, understandably, getting texts and emails and messages from clients saying what's happening. So we at Sumner Immigration Law put out an email blast to our clients that said, this is what we know so far. This is what the proclamation said. And basically said, if you're overseas right now and you're in H-1B status, it's probably a good idea to come back in, because at that point, we did not have clear information about who this would affect and not affect. So we sent that information out. There was widespread panic, of course, amongst individuals and employers who were potentially affected. Fortunately, if we can use that word in this situation, we did have additional information, some additional information as of Monday. So over the weekend, some additional information was pushed out via social media, which is not the way that usually these announcements are made, but additional information was put out over social media that basically said this would affect only new H-1B petitions. So as of Monday, we did have some additional FAQs, some statements from the White House, USCIS, the Department of State, and CBP, the agency that is at the port of entry. So according to the proclamation and the FAQs that they have put out, what we do know as of right now, and this is subject to change and subject to change as we have more clarity from the administration, which we don't have very much of right now. As of what we know right now is this applies only to the H-1B classification, okay, as of right now. So we have lots and lots of people asking, understandably, all good questions, all reasonable questions, but we have lots of people asking, I'm on TN, I'm on H-1B1, I'm on A3, am I affected? The answer is no, per the wording of the proclamation. We're still, and again, I can't give legal advice here, but we're still cautioning clients who are traveling, and we're prepping them as much as we can with additional information, to make clear to the officer at the port of entry that they are not affected. But you're not affected if you're on a different visa classification. In addition, the green card process is not affected. So this proclamation only affects the H-1B classification. It restricts entry of an H-1B worker into the United States unless a $100,000 fee is paid. Again, lots of questions there, right? So we know that it only affects the information that we have. Official information says it only applies to petitions that were filed on or after September 21st of 2025, so a couple days ago, and that it's valid for 12 months and can be extended. The FAQs also say that the Department of Homeland Security is to, quote, restrict decisions on petitions that are filed without the $100,000 fee for H-1B workers outside of the United States. So we've had a lot of questions about Does this apply to extensions, amendments, transfers, petitions? In other words, H-1B petitions that are filed for individuals, H-1B workers who are currently here in the United States? The answer seems to be no. I say that for a couple of reasons. One is based on the official information, as limited as that is, that we have from the government. The other reason is that the basis of this proclamation is Section 212F of the Immigration and Nationality Act, which does allow, it's broadly worded, and does allow the president to restrict the entry of certain foreign nationals for certain reasons, for national security reasons. So because it's based on that, it can't, like, legally, it should not apply to individuals who are here in the United States. So, and I also have checked even this morning, we have not filed H-1B petitions yet that have been received by USCIS in the past couple of days. You know, we're filing them yesterday or today, but they haven't been received by USCIS. But I have talked to some, or not talked to, but I've heard from some colleagues who have filed online. They have filed amended petitions, extensions, transfers, things like that without the $100,000 fee, and they're being accepted. They're being reseated. So that's hopeful information, cautiously optimistic there. What we also know as of now is that there could potentially be exceptions for either individuals, for specific companies, or for a particular industry. That's literally all the information that we have about that. It's called the national interest exception, not to be confused with the national interest waiver, which is a different type of green card process, but there is the potential for an exception. As of right now, I don't know of any exceptions that are official. I've heard or seen, you know, headlines floating around, and have heard other immigration law colleagues say that potentially medical doctors would be exempted, but I have not seen anything official. And as of this point, it is not official. So what does this proclamation, who does this proclamation not apply to? Other visa classifications, like I said. The big question, in addition to, you know, other visa classifications like the H-1B one, the TN, the E3, all of that, there's no official word as to whether this applies to the H-4. So the H-4 derivative application, or the H-4 classification rather, is for dependents of H-1B visa holders. There's no official word as to whether it applies to that classification or not. We would think not, because it doesn't specifically say that. But again, there's really limited information available at this time. Like I said, it does not impact any sort of green card processes. We believe, but nobody is for sure 100% right now, we believe that it does not affect extensions, transfers, amendments, et cetera, for individuals, or even a change of status for to H-1B for individuals that are physically present in the United States at this time. And it does not affect, this is important, it does not affect petitions that were filed on or before, it doesn't affect petitions filed before September 21st of 2025. That's really important, because that affects the H-1B cap petitions, many of which are still pending. So for the H-1B lottery that we had in March, if a petition was selected and you filed the petition between April 1st and June 30th, and that petition is still pending, or if it's approved, those petitions are not affected because they were filed before September 21st of 2025. So, you know, take that with a grain of caution, with a grain of salt. I haven't, just a quick message here. I have a note that I'm offline in LinkedIn. I had technical difficulties with the LinkedIn event. I apologize for that. I hadn't used that in conjunction with StreamYard before. I'm showing that I am live on my LinkedIn page. So if you want to join there, if you're not already, and then I'll share this again on our LinkedIn page as well, or on my LinkedIn page. So I apologize for those technical difficulties. So like I said, we believe at this time that it does not affect individuals who are here in the United States where petitions are being filed for them, whether that's extensions, transfers, amendments, that type of thing. Oh, and I was also talking about the H-1B cap petitions. If they've already been filed or approved, if they're still pending, whatever it is, they're supposed to not be affected. I say supposed to because we don't know exactly how this is being implemented. I'm going to talk in just a minute about what we don't know, but we don't know how this is being implemented. some of the FAQs also indicate that a person who currently has a valid H-1B visa is not affected, and their ability to travel in and out of the United States is not affected. Take a deep breath. You just heard me take a deep breath. That should be true, but again, we don't know how this is being implemented. So for right now, until we have additional information, we're cautioning clients against travel if at all possible. I recognize there are other reasons that there are other reasons you may need to travel. There are significant reasons you may need to travel. Maybe you have a family emergency, somebody is sick, perhaps a death in the family, a wedding, it could be a happy thing. So talk to your immigration lawyer, whether that's us or another person. If you need to travel and you were potentially affected by this, but you're not sure, talk to us. We're answering a million emails right now as we speak from clients. If you're not a client, unfortunately, we can't give you legal advice because we just don't know your situation. But if you're a client and you have travel plans coming up, let us know. But for now, we're saying stay put if you can, but we know that that's not always possible. And like I said, if you already have a valid H-1B visa, you should not be impacted, and we're arming clients with additional documentation. What we do not know as of this point, like I said, this is not very clear, the way that the proclamation was written. And to be honest, the way that the proclamation was done is not the way that it's usually done, that this type of thing is usually done, right? So sometimes we do have executive order where a president will make a decision and put out some information, but typically when there's a change like this, it's done through the Administrative Procedures Act, which is it's a law. It's the way that regulations are formed, and changes to processes are typically done. Not always, like I said, there can be an executive order, but a lot of times it's done, most of the time it's done through the Administrative Procedures Act, where you have a proposed rule, also known as a regulation. You have a comment period where people who are potentially affected can submit comments to the government. The government has to review those comments. They may or may not agree with them and may or may not incorporate them into the final rule, but they'll look at the comments, they'll publish a final rule. There's a waiting period between the publication of the final rule and then the actual date that it becomes effective, and then it's effective. Obviously, that's not what is happening right here. There was a proclamation on Friday and we're done. That's it. It's supposedly been implemented. So back to what we don't know. National interest exception, we don't know who that will be, if that will be, who makes that decision. We just don't have that information at this time. How to pay the $100,000 fee. So should there be a company or organization that would like to pay the $100,000 fee to have someone in who is affected, to bring in an H-1B worker who is affected, we don't know how that payment would be made, how it would be made, who it would be paid to, what fund those fees would be put into, who that would benefit. We don't have any of that information. We're also not certain regarding individuals who are in the country right now in H-1B, valid H-1B status, and who would like to travel in the future. So it's not clear if a person who, let's say you're in the United States right now in valid H-1B status, whether it's cap subject or cap exempt, we don't know how this rule will be implemented in terms of your traveling overseas to get an H-1B visa stamp and then re-entering the United States. So if you're in that situation where you don't currently have a valid H-1B stamp, absolutely talk to your immigration lawyer before you leave the United States or make travel plans, because we just don't have information on that particular point right now. We're not certain how people in the country, that's what I just said. Yes, so that's what we don't know right now so far, which is a lot of information, and it's very unsettling, and it's hard to make plans. There's a lot going on. I get it. We will continue to push information out as we can. So through our email newsletter, through my LinkedIn page, which you may be on right now, the YouTube page, we'll keep pushing out information as we have it. What to expect next. So I do fully anticipate litigation. As soon as Friday afternoon, there were posts by immigration attorneys, and when I say posts, some were on LinkedIn, some were through emails. I'm on listservs, and there also are groups of immigration attorneys, forums of immigration attorneys, so posted in multiple places, attorneys that are looking to put together litigation, namely Greg Siskind and Charles Cook. That last name is K-U-C-K. Anyway, they are looking to put together litigation. I don't think that they have filed anything yet, but I could be wrong about that. But they are looking to litigate on that. They are looking for individuals who are affected in organizations, specifically organizations who are affected now. So it's not just like, oh, I'm in H-1B status and I want to travel and I'm not sure if I'm going to be affected or not. That's not great in terms of standing for litigation. So they're looking for specifically organizations or individuals who are impacted right now by this rule. Who knows what the outcome of that litigation will be, right? I think in previous years, there was there's been a lot of litigation over the years about a lot of different things. That's a really broad statement. But my point is, during the Trump administration 1.0, the previous Trump administration, there were changes that were made, and some of those changes were struck down by federal litigation. We don't know what's going to happen. Nobody can predict what's going to happen there. And it could be, I expect a lot of whiplash, meaning I expect that there will be litigation. I expect that there will be temporary stays where this is not implemented, and then that could change at a moment's notice, or without a moment's notice, could be changed immediately, could ultimately go to the Supreme Court. Who knows? And who knows? There's a lot at play there. So we don't know the outcome. What I'm saying is, yes, there's litigation, and hopefully that litigation would be helpful and at least make this a fair process with, notice and kind of follow the rulemaking process that is supposed to be followed. But we don't know the outcome of litigation at this point. In addition, what to expect next, the announcements that were put out in the proclamation and then also in some of the FAQs and other sources say that we can expect additional changes to the H-1B program, namely, and we have seen those already, namely the changes that they say, and there could be others as well that are coming, but the changes that they say that are coming are a proposed regulation for changing the prevailing wage system for H-1Bs. So if you're involved in H-1Bs, you know that there is a minimum amount that H-1B workers have to be paid. That's to protect US workers and the H-1B workers. Anyway, they say that there's going to be a proposed rule there. They also say there's going to be a proposed rule for the weighted selection and the H-1B cap process. That rule was actually the previews, if you will, of that rule was actually published today. It's available online. It was just published earlier this morning. So that, I have not read it in detail. I've skimmed it. It's 105 pages, but it would change the way that the H-1B lottery selection is done. In all these years so far that they've had the H-1B lottery, the selection has been done randomly. So you just select or not you, but USCIS, you enter into the H-1B lottery, and then the selection is done completely randomly. So, right now the selection is done based on passport number. So people ask every year, and it's a great question, hey, does it matter that my degree is in X, or does it matter that my salary is Y? And the answer has been no, but this year that could change if this rule comes into effect. It's important to note that for these two rules, so keep in mind that prevailing wage rule is not in place at this time, and it's not even published. We don't know what it's going to look like. The one that would affect the selection of the H-1B cap cases has been published as of this, or the preview has been published as of this morning. So it's good in a sense, to the extent that there's good news here. It's good that those are going through the actual Administrative Procedures Act process, and that we're seeing the proposed rule ahead of time. We have a chance to comment on it, and then hopefully there will be a notice period before the implementation. No one knows at this point if the weighted selection, or the prevailing wage for that matter, but if the weighted selection rule will be implemented in time for the H-1B lottery in March of 2026. I would imagine that's their goal, but we don't know. Nobody knows for sure what that timeline will look like right now. So, like I said, we've covered a lot here. We did give people the opportunity to submit questions ahead of time, and I think a lot of those questions, maybe not all of them, but a lot of those questions were answered here. If you have joined us late, you might not have caught it. It will be up on our YouTube page, our Facebook page, and my LinkedIn page, so you can rewatch it as needed to catch the information that you might have missed. We have a couple of some questions here that I'm going to try to answer. I'm going to stay on until for another 10 minutes or so, till 12:35 Eastern. So if you have additional questions, put them there and I will try to answer them. Keep in mind, like I said, this is not legal advice. and if I'm your lawyer, then contact us directly and we're happy to help you. But this is not legal advice. We are happy to help. If you have questions, if you are looking for an immigration lawyer to help you navigate this process, absolutely, we are here. Contact us. There will be our contact information on the outro. So at the end of this, after I finish, there was something else I was going to say. Oh, yes. So we will keep pushing out information as information is available on all of these sources, and on our contact information will be on the outro. I think the important thing to keep in mind right now is that, yes, there absolutely are going to be changes. There are changes already, obviously. I am not mitigating the severity of these changes. These absolutely can be significant, can really impact both individuals and companies. Absolutely. At the same time, what the administration wants, is to create chaos and panic and anxiety, and to basically for people to give up who are in the United States or hiring foreign nationals. So take a deep breath. Let's walk through this one step at a time. We absolutely will get through this. We are here to help you navigate this as best we can. Some practical tips other than breathing deeply and eating your comfort food of choice. That's not legal advice, but to a limited degree. But you do have to take care of yourself. But other practical advice is, if you are a company who sponsors H-1B employees, especially for the H-1B lottery, start thinking now, and we are starting to have this conversation with our corporate clients, but start thinking now about possible alternatives, especially with this difference in the proposed rule with the weighted selection. I'm not saying to totally discount the H-1B lottery, and honestly, it has not been a shoo-in by any means. For the past several years, the selection rate has been 26% or less, depending on the year. So it's never been 100% reliable source. So even more now, start thinking outside the box about other visa classifications that you might be able to use, other ways that you might be able to hire and retain foreign national talent that your company needs. Same thing if you are a foreign national, start thinking about if you are going to be entered into the H-1B lottery, start as soon as you can, and this applies for companies as well. Depending on the situations, if you're able to enter into the H-1B lottery, don't wait until that last year. So many people will say, oh, I have STEM OPT, and they'll wait until their third year, and they've missed other, the previous 2 years opportunities. So start early if you can, but even if you're early on in the process, start thinking about alternatives, because sometimes, like if it's an O1 visa, it takes time to build up your resume, and not everybody is going to qualify for the O1, by the way. But if you do, it sometimes takes time to build up that portfolio or the resume to have a solid case. So start thinking now, start having conversations about potential alternatives. Stay tuned, because like I said, we will publish updates as we have them, including updates on litigation, any litigation that happens. So we have a number of questions here. One question I don't think is relevant to this. Do you think this might increase odds of selection this year for those present? Well, maybe it is relevant for those present in the US. I don't know the answer. We'll have to see. I don't know the answer to that. I do think this is probably going to have a chilling effect. I think there will be some employers who don't necessarily understand that if you have a person who's present, and as we understand it right now, and this is subject to change in interpretation, but as we understand it right now, at least as I understand it, if you have a person who's physically present in the United States, let's say on OPT, the $100,000 fee, as far as we know right now, does not apply to you. Although that's not clear. To be clear, it's not clear. So I do think it'll have a chilling effect, and we'll have to see what happens. But like I said, that does not mean that everybody should totally discount the H-1B lottery and just give up and not participate. If an H-1B extension is approved and a person has to travel back to get the stamping done, will he or she be affected? I don't know the answer to that. I don't think anyone does at this point. It seems to me if the H-1B petition was approved before, or filed rather, before September 21st, 2025, then you would not be affected, but we don't know the answer to that as of right now. And a lot of the answers to these questions I think, are not going to come from the government. They're going to come from firsthand experience. So it's going to come from other lawyers and individuals and companies reporting to each other about what's going on, which is not great, but that's where we are. I say it's not great just because it's not consistent and widely available. Another person asks if it's safe to apply for a B2 extension. I'm not going to address that just because it's situation specific. I will say that the guidance has said, not the guidance, the FAQs have said that they're going to crack down on the use of visitors visas to enter the United States as a way to avoid the $100,000 fee. That's not what that particular question was about, but just know that they are aware that people are doing that or may think about doing that. But that being said, if you are if you have the visitor's visa or applying for the visitor's visa for the correct purpose, then absolutely, there's not a reason, proceed with caution and talk to a lawyer, but there's not a reason not to do that. So a question about so many questions about does this rule apply to next year's lottery? Yes, it seems like it will, assuming it's still standing, assuming it's not struck down by a court. And it's TBD whether it affects somebody who's here in the United States already and is looking to change status from, for example, an F1 status to H-1B. We'll see what happens. Like I said earlier, I think that it would not apply just based on the underlying statute, the 212F, that it affects individuals entering the United States, but we'll have to see. And I really hope we'll have more information on that in the weeks to come so that everyone can plan accordingly. Does this apply to nonprofits as well? As of right now, yes. So I don't know, but maybe the reason the person asked that is certain entities are cap exempt. They don't have to go through the H-1B lottery. It is institutions of higher education and certain nonprofit organizations affiliated with institutions of higher education and certain other organizations. Anyway, there are cap exempt organizations. And yes, as far as we know, it applies. There's not been anything that says otherwise. There's a lot of confusion in the cases of H-1B transfer to new employer and during renewal after first 3 years. So transfers and extensions. I talked about this a bit in the first part of this live session. And I was saying that it's not clear as to whether that applies or not. However, I think that it does not as of right now. The reason I say that is a couple of things. The basis for it, like I said, 212F is the section of the Immigration and Nationality Act that this is based on, or at least referenced in the proclamation. And that section of the INA, Immigration and Nationality Act, does allow a president to restrict the entry of certain foreign nationals for national security reasons. So that wouldn't apply to individuals who are here in the United States. The other reason I say that is just practically speaking, we've heard even today from colleagues who are submitting transfers, extensions, amendments, things like that successfully, and they're not being asked for the $100,000 fee, which is good. All right, so I'm going to end it here. I'm so glad that all of you joined us. If you have questions, feel free to keep putting them in the comments. I'll keep checking these comments as time progresses, and I'll answer if I can. Otherwise, I'm so glad that you joined us. Feel free to contact us if you have additional questions or if we can be assistance. There will be contact information right after the end of this session. My name is Emily Sumner with Sumner Immigration Law. We assist clients from around the country and around the world with family-based and employment-based immigration matters. I hope you'll join us next week, next Tuesday at 12 noon for our next Live at Lunch. Until then.